Yes, Counsel. Good morning.
Good morning. May it please the Court, Amanda Rowan, Assistant District Attorney for Middlesex County. When the legislature enacted 10J, they clearly did so with the intention of broadening the scope of weapons that are illegal in schools. 10B is a felony that's already in place that deals with what I'll refer to as the outside world. 10J is a misdemeanor that deals with weapons in schools. When the legislature enacted 10J, they did so with a plan. The way that we can see that is from looking at what happened around that time. 19 days before 10J was placed into effect, the legislature enacted 37H. 37H is a very similar statute, although it is civil. However, it specifically deals with weapons in schools. They wrote, the words were, no knives or guns or other dangerous weapons. 19 days later, they enacted 10J. No firearms was the word that they used, or other dangerous weapons.
But 37H applies only to students, and 10J can apply to the person running the woodworking shop.
Exactly.
I mean,
exactly.
Is a knife in a woodworking shop an illegal, dangerous weapon unless the shop teacher gets this permission?
What we need to look to in the application of 10J is what is the purpose of this item. Educational items make sense in schools. Shop class, a scalpel in science class.
But you're talking about a criminal statute here,
Yes.
so, you know, you've got to look at it. I mean, I don't think it would necessarily be appropriate to say, well, we really know they couldn't have meant shop instruments.
What the legislature intended to make illegal was knives and guns in schools. In this particular case, they don't turn to 10B for the definition, which is what the juvenile's argument is. The closest analogy that we can look to for what the legislature's intent was when they enacted 10J is 37H. This is a case of first impression, so there isn't much to turn to. So what we need to look to is what is the most analogous situation. 37H says knives and guns and other dangerous weapons. It does not refer to another statute. It does not define what is a knife, length, blade, etc.
So all of those teachers with Swiss Army knives are now in violation of the criminal statute.
Right. Or the parents of this juvenile.
With respect to knives, yes.
Okay. And a college student who, because this applies to the grounds of a college, so
Yes.
a college student in his dorm who has a Swiss Army knife.
It's a carrying offense.
So if he carries it in his room, he's in violation of the law to carry a Swiss Army knife in a dorm room in a college.
It is, Your Honor, and the reason for that, and the reason for the Commonwealth's position on this, is that knives are traditionally a dangerous weapon. They may have other uses.
They have lots of other uses.
Exactly.
I don't know anyone that doesn't have a Swiss Army knife. Maybe that's just my generation, but they've got lots of things on that knife.
That's correct.
Screwdrivers and scissors and
Absolutely.
corkscrews and stuff like that.
Might look over at this end of the bench.
Absolutely. And while there are other uses for them, the Commonwealth cannot deny there's another use for a Swiss Army knife. We can't deny that in shop class there are situations where something which might be considered a knife would come into play. But when the legislature created this statute and when under Doe, which is, again, the closest, most analogous situation, that the plaintiff in that case, but that was the individual who was expelled because she brought a knife into school, which clearly was not per se under 10B, brought this argument. This honorable court said...
that section 37H uses the word knives.
Correct. Understandable. The reason why knives are encompassed in other dangerous weapons, when they say firearms or other dangerous weapons, is because there is no clearer dangerous weapon than a knife. If we were dealing with a more innocuous item, an item that could be as used, etc., that would be a different argument. But when they say firearms or other dangerous weapons, there's no other weapon that has traditionally been accepted by the general public as a dangerous weapon than a knife.
So are you looking to what, the common law definition of dangerous weapon?
The common law, 10B, and what's generally accepted as a dangerous weapon would be the per se weapons or an as-used weapon.
Right.
The reason why 10J has a broader application is because, first of all, those per se weapons, they don't encompass all of the things that we don't want in schools. I apologize.
Understood.
They don't encompass machetes. They don't encompass huge meat cleavers, items that we clearly agree we don't want students walking around with in their
No one's
hands.
suggesting that you can't list all those things in the notice that's really required prior to expulsion, and that seems to me a perfectly appropriate. The legislature thought it was appropriate. Schools were enacting it all over the place. They signed these things. We're talking about something else on top of a very serious sanction of expulsion,
Yes.
and now adding to that this very broad category, which has a notice requirement in it, send it out to students, let them know, to a criminal sanction, which requires them to know what is intended. And I can't yet hear what is intended that makes sense, that you can actually understand and apply in every case. Every single knife, except the ones we don't want. I mean, that's really not standard, is it?
Knives are not allowed in schools.
Right, and you get expelled for that.
And
So
that's-
now let's make it a
Knives are not
crime.
allowed in schools if held by students, but the statute doesn't say that.
The statute says it applies to everyone equally. It's interesting also that they broaden 10A. They say they don't look to 10A for a definition of firearms. They add pellet guns, which was clearly not a firearm under 10A.
Right.
They also include individuals who have a license to carry a firearm out in the outside world can't bring them in schools. The legislature was looking at schools as a safe haven, the place where you send your kids, usually, although of course college students are older, where we shouldn't have to worry about, we don't need to get to per se, and we don't want to get to as used because now we're dealing with assaults. We don't want to get to that point before it becomes illegal.
So you reject that dangerous weapon should be defined as either per se or as used. It's something else.
Under 10J, knives
Something
and
else,
guns.
even though nobody says anything, it's something else, and we're supposed to figure out what it is. Is that?
When the words that they use, the plain language, is firearms and other dangerous weapons, and when the question that this particular trial court brought to your attention was specifically related to knives, yes, firearms and knives.
And if it was not this student, but the parent
Yes.
who had a Swiss Army knife, who, because the student threw a water bomb at somebody, had to come in and talk to the principal, it would be fine to prosecute the parent as well, correct?
Correct. Under this statute, it's the Commonwealth's position, it's no knives or guns in schools.
Well, surely the Commonwealth can pass such a statute. The question is whether this means that, where the term dangerous weapon has had a very different meaning attached to it in our jurisprudence.
Completely understandable, except with the exception of the Doe case. The Doe case specifically stated, if the legislature meant for 10B or as used, the words they used are, they easily could have done so, which it did not. If the legislature intentionally omits language from a statute, no court can supply it.
But
so
it
what-
says knives. 37H
It does
uses
say
the
knives.
word knives.
It does say knives. It does
And
say
the lipstick
knives.
knife was a knife.
Correct, and it was a knife that would not have been considered under per se.
But again, when there's a term like dangerous weapon and it's not defined in the statute, I mean, where do we ordinarily look? Don't we look to the common law to determine what a dangerous weapon is?
We can look to the common law, but we can look to the plain language of the statute.
Dangerous weapon is the plain language of the statute.
Exactly, and
Yeah.
dangerous weapon, in the common people's understanding,
Common
encompasses a knife. It is a generally accepted, this court, and I apologize, it was Commonwealth v. Super, or I apologize, Commonwealth v. Miller, which the juvenile actually cites. Most knives can be used to inflict serious bodily harm. And when we're talking about a school, we don't want those items in the schools.
I understand that, and you can be expelled. It's right in there, 37H. That's a very specific statute that talks specifically about knives, among other things.
There's an argument also that can be made. Expulsion in this day and age is such a serious repercussion with such serious consequences, which leads to the due process issue, the notice issue that we also dealt with in the brief. this student was on actual notice, not the usual other laws that they just accept as I might get in trouble for that. They were actually given a handbook that actually said no knives or guns. And then he chooses to engage in prohibited conduct. He knew that what he was doing was wrong. He knew that what he was doing could cause an expulsion, which carries with it, under an expulsion, no other school district has to take you. That's not finishing high school. That's no college. That's your entire future. This is being charged with a misdemeanor. We're talking about a constitutional right to an education that can be taken from you if you engage in this conduct.
Well, you have a constitutional right to have clear criminal statutes as well.
Correct. Correct. And the 37H and the fact that they use knives and guns and knew that language when they decided to enact and add into law 10J, the Commonwealth's argument is that it was an eye towards understanding firearms and other dangerous weapons encompasses knives.
So you're saying that if the UMass police did a sting at a kitchen in UMass and found somebody watching a Top Chef show and grabbed them with a knife, you'd be making the same argument here because they're equally in violation of 10J if they're in a UMass dorm.
Yes, the law applies through college. It does. And the plain language of the statute, again, their intent was so clear, it makes, to go with the 10B definition would make no sense. It would make 10J superfluous and moot. Essentially, it would say, in the outside world, you have a weapon that's a 10B. That's a felony with a state prison sentence. It would be a mitigating factor to bring it into an elementary school.
But what if you don't do that, but you look at something like the appeals court decision in Commonwealth versus Turner,
Yes.
finding a 3 3/4-inch serrated blade not to be a dangerous weapon. So you don't say that it's, you read 10B into 10J, but you look at the usual common law understanding of dangerous weapon. It's either per se or as used. Here you've got a knife, 2-inch blade, folded knife in somebody's pocket, and the judgment could well be made that as used, that's not a dangerous weapon.
Turner very clearly focuses on the 10B and the as used, as well as the fact that we're in the outside world, but also it really weighs heavily on wholly innocent conduct. This juvenile in this school who knew and had noticed that he should not be bringing knives to schools, as does everybody because we know they receive actual notice of this, and common sense says, I probably shouldn't be bringing a concealed knife to school.
I don't think anybody is saying that he couldn't have been expelled under 37H.
But I think because Turner was dealing with the criminal statute and they focused so much on wholly innocent conduct in this particular case, it's distinguishable. We have to have different rules for kids in school than adults in the outside world. And that was what the legislature meant, which is why they created, instead of saying it's a felony or it has a higher consequence, they're saying if it's a 10B per se or if it's as used, we're still going to use the same law that would apply to everyone. But there's so much that's not covered by 10B. And to wait until the point that the kid with the meat cleaver stabs or kills someone is not acceptable.
But if under 10B, it would still be if it's as used in that fashion, it would then still be a dangerous weapon under the common law.
Yes, it would be. But this is the carrying offense. They don't want to get to the point where someone is as using, for lack of a better term, a meat cleaver on another kid until they can intervene criminally. They don't want to wait till that point.
Unless he happens to be in a dorm kitchen cutting chicken. The problem is that you better give fair warning to UMass students that
Absolutely.
They're violating the law when they go into the kitchen and use anything but forks and spoons. That's the inherent problem you've got.
Understandable. But I think what we really need to look to is the intent of the legislature and the notice provided to individuals. And in this particular case, it's the Commonwealth's position. 25 years ago in TLO, the Supreme Court of the United States specifically pointed out that there's enforcement of rules against conduct in schools that would be perfectly permissible for adults. And that's exactly what our position is in this case. We're not asking for 10J to go any further than the outside world, but the reality is 10B is not sufficient to keep kids in school safe, which is why they enacted 10J.
Thank you, Counsel.
Thank you very much.
Victor Tice on behalf of the juvenile. I think I'd begin by stating I don't understand where the distinction comes between the outside world and the school. That's nowhere in the statute, and the Commonwealth would be well within its rights to charge anybody who brought a weapon that falls under 10B to a school under 10B.
But you agree, I think, that that the legislature can rationally do things in schools that are more protective than they would do outside of a school.
Oh, I agree, and they did, but my point would be, the argument I heard was that 10J and 10B become mutually exclusive, and that's not true. 10B doesn't stop at the property footprint of the school. It continues to be in full force and effect and can be used to charge. And when you take that and look at the fact that the closest analogy for language of 10J is not Chapter 7137H, it's actually 10B. The language is identical. Other dangerous weapons.
What purpose does 10J serve? We don't usually think that the legislature is doing nothing when it enacts a statute. It's got something in mind, and so what purpose does it serve?
I think the point was made that it applies, and many justices have noted, it applies not just to students, but to everybody who comes on school grounds. So for school board meetings, for athletic events where parents, we've seen in this Commonwealth, can get into some heated disputes with other parents or coaches, that they want a broad category that weapons shall not be brought to school, not just for students, but for everybody.
But if this dangerous weapon is, as you say, it's already actually defined in 10B, it's already illegal to carry it, well, what's the protection?
Not for, as I pointed out in my brief, there are some weapons that would be per se dangerous that would fall under 10J but not 10B. 10B is not the limit of per se dangerous weapons. 10B just happens to be the statutorily outlined per se dangerous weapons. Long before 10B was put into effect, there were weapons at common law that were per se dangerous. A good example would be a sword. It's an item that's designed solely to inflict serious bodily injury or death. That's a per se dangerous weapon. Unlike a pocket knife.
So we're getting at swords here? We don't want any swords on the school grounds? Is that what 10J is all about?
I'm saying that 10J, the example I use, is a more modern version, mace. Mace is not specifically enumerated by the legislature under 10B as a per se dangerous weapon, but the case law has stated it is a per se dangerous weapon because its only function is to inflict bodily injury. So it would not be a crime under 10B to walk around with mace. You can be licensed to do so. But for 10J, I could walk onto school grounds with a canister of mace and be in no violation of any Commonwealth laws. However, the legislature has said that the school grounds, including universities and colleges, should be offered more protection than the regular street corner. And that's why it's important not to simply throw away the longstanding definitions of per se and in-use weapons. Because in this case, there's absolutely no dispute that the knife in question was not a per se dangerous weapon.
All right, well, tell me again. Let's focus on the common law. We don't have a definition in the statute. What does the common law say a dangerous weapon is?
Clearly, under Miller and Turner, a knife such as this with a very short blade length, folding knife, is not a dangerous weapon per se. It's only a dangerous weapon if it's used as such. And that's because the recognition, contrary to what the Commonwealth says, is knives are not the be-all to end-all of dangerous weapons. The variety and multitude, particularly...
So what is the definition of a dangerous weapon under the common law?
It has to be per se, meaning it's inherently designed to commit serious bodily injury or result in death. That would be a per se dangerous weapon, or as used as such. An example would be a rock. Lying on the ground has no inherent danger whatsoever, but if picked up and used in a threatening manner, it now becomes a dangerous weapon.
Well, it becomes a dangerous, I suppose it becomes a dangerous weapon for terms of assault and battery of a means of a dangerous weapon. Is it also a dangerous weapon under B?
Under
rock? 10B? Yeah.
Only if I'm faced with a law enforcement officer who's arresting me on a breach of the peace or a warrant, and I pick it up and I say, you're not taking me into custody. That's what Turner dealt with. Because in Turner, the knife was closed in the gentleman's pocket. There was no threat to the law enforcement officer. So since the knife wasn't used as a dangerous weapon, it can't be considered a dangerous weapon.
And a baseball bat, I assume, would be the same.
Baseball bat would absolutely be the same. So every baseball team that came to play at a school, under the Commonwealth's argument, they'd have to get permission to bring their bats onto school property.
So what kind of knives are per se dangerous?
The legislature's picked several: dirk knives, daggers, double-edged bladed weapons. They've said those are per se by statute. And I think at the common law, they would be considered per se dangerous weapons under the statute. There's fighting knives, combat knives, trench knives. There's a variety of knives that were designed solely for the purpose of inflicting maximum harm to another human being, versus other knives. The kitchen knife has been noted as such, particularly the Swiss Army knife, where that would be probably one of the last weapons you would want if you were actually intending to cause physical harm. Non-locking blade, very short blade length.
They seized them at the airport.
So under those rationales, that knife falling out on any street corner, supermarket, movie theater, you're well within your rights. Any parent, any teacher, any college-age graduate student who rides their bicycle on and keeps a Swiss Army knife or a multi-use tool, that's even more prevalent in the modern age with a similar short blade length, would be prosecutable under this statute. And there's simply not sufficient notice for that, given the language that the legislature used under 10J.
So if they had said knives, obviously, it may not make a lot of sense when applied to UMass students, graduate students, but that you would not have your argument. Yours is a lack of clarity.
Absolutely. They intentionally used language that had been long-standing by statute, other dangerous weapon, and they didn't include knives, which they did under 37H. And again, that dealt solely with students in a civil context, and more importantly, the maximum result was may yield expulsion, didn't mandate expulsion. It still have tremendous discretion, where under the criminal statute, once this young gentleman was charged, all the rights and privileges that he had to being innocent went out the window, and now suddenly he's faced with a crime, and that's a very serious matter. I would say far more serious than expulsion. And I also would take note that there was no evidence whatsoever offered at the lower court imputing a Doe-type standard that he had notice of a handbook. This was a stipulated evidentiary hearing on the police report, and the police report actually stated the knife, there was no nefarious purpose. It was kind of argued that this young man came to school knowing that he was in violation and some sort of unlawful act on his part. It was a birthday present from his father that, by all accounts, it slipped out of his jacket pocket.
But it's not an element to the crime.
But it was an element to the Commonwealth's argument, because what they want to try and do is ratchet the emotional tension up to make schools a more sacrosanct environment, and that we have to protect children and kids. And that argument too narrowly focuses the whole outline of the statutory scheme, which is it applies to everybody, not just kids. The legislature wasn't seeking to protect just kids. They applied to adults.
Although one could argue you protect kids when you keep adults from walking into a school with a knife.
I would hesitate to call university students kids. It applies to all graduate students, Harvard University. I wouldn't say that everybody attending there is a kid.
You clearly don't have a child who's in college.
So I believe strongly that the long-standing definitions of dangerous weapons apply to this case. There is no lack of clarity. We've had an understanding based on Miller and Turner of what type of weapon would constitute, and it doesn't fall under 10J here. And there is no discord between the two statutes. The 10B applies equally inside as well as outside, and 10J gives some additional remedies for a variety of items that, if used in a dangerous manner, the school police resource officers can take criminal action. But to
Your client expelled as well?
No, he was not. And I think that's significant. There are alternative remedies that the school administration has in an incident like this, where he cooperated fully with the police. But it really goes to the notice requirement, because it's not fair to separate out the juvenile in question from all the other host of people that would be exposed to this statute, and to say somehow because he had a student handbook, may or may not have had access to that, and may or not have known about what he was supposed to bring to school or not, he's now subject to a heightened standard of a definition of a knife that's a dangerous weapon that has never been held as such in the Commonwealth. And that would separate him into a whole other category from the adults, teachers, anybody else that 10J could apply to that didn't have any coverage whatsoever under 37H. So I really don't think you can compare the two, particularly where the legislature was well aware of the language choice they made on that section, and they didn't intentionally impute it and bring it in to 10J. They intentionally left it to be the same standard that had been in place since 1906 under 10B. And for those reasons, I firmly believe that this knife in question should not be classified as a dangerous weapon unless there's some evidence that it was used as such, or even going to be used as such. I do think Judge Ferry indicated, and I think it would be a careful factual analysis for a fact finder or a juvenile court to take action, but if there was evidence that there was bragging to a student, I've got this knife, there's going to be a fight after school, I'm ready to go, I've got some extra ammunition on me, that would change things. And it wouldn't just be, innocent carrying, but there would be some extra intent and effort there. But that's really what's required, is some evidentiary showing that it wasn't just a knife that you can buy in any hardware store, any sporting goods store. Millions and millions have been sold, and no one in their right mind would think that it's a dangerous weapon.
But the dismissal and your argument doesn't depend on the facts of this case. It depends on the language that was used. I mean, that's the difference between this case and Turner. Turner is there wasn't sufficient evidence to convict him. But this is a challenge to the statute.
I think it would be both. I think it's both a challenge to the statute and under Turner. The same analysis under Turner would apply.
But the issue that's just been reported to us is really the statute.
Well, the same language in Turner was other dangerous weapon, defining that does a 3-inch folding knife with a serrated blade constitute a dangerous weapon in Turner. Here it's a 2-inch folding knife. So it really is a sufficiency of the evidence based upon the definition of other dangerous weapon. And the same similar type argument that there has to be a heightened scrutiny because safety of law enforcement officers, it was, again, this legislative intent to ratchet up the stakes was rejected in Turner because at the end of the day, they held that the very knife in question just can't, on its face, without being utilized as such, be considered a dangerous weapon. If there are no further questions, I'll rest on my brief.
Thank you.